Contract law, remedies, rescission. Rescission is an equitable remedy in contract law. It is available where a contract is found to be voidable. It is necessary to distinguish the difference between a void and a voidable contract. A void contract simply does not exist, it never existed. This is often expressed as void ab initio, meaning void from the beginning. Whereas a voidable contract exists and will continue to exist unless the innocent party decides to have it set aside. A contract may be voidable as a result of vitiating factors such as misrepresentation, mistake, undue influence or duress. Rescission involves unraveling the contract and putting the parties back in their pre-contractual position. For example, in a contract where Ivor agrees to sell his farm to Jacob for £1,000 having misrepresented the income of the farm. If Jacob wishes to rescind the contract, he would get his £1,000 back and Ivor would get back the farm. The right to rescind the contract may be lost where 1. A third party acquires rights in the subject matter of the contract, 2. Where the representee affirms the contract, 3. Through lapse of time, or 4. Where it is impossible to restore the parties to their pre-contractual position. 1. A third party acquires rights. If a third party acquires rights in the goods, for example, where they have been sold on or made subject to a charge or mortgage, rescission will not generally be granted. This is because it would prejudice the third party rights. If, however, the representee does an act to rescind the contract before a sale has taken place, the third party has not yet acquired any rights. This was seen in Car and Universal Credit v. Caldwell. Mr. Caldwell had been able to avoid the contract by reporting the incident to the police and contacting the Automobile Association to try to locate the car. 2. Affirmation of the contract. If the representee does an act to adopt the contract, or demonstrate a willingness to continue with the contract after becoming aware of the misrepresentation, they will lose the right to rescind. In Long v. Lloyd, the claimant lost his right to rescind as he agreed to accept half the cost of repairs on discovering the faults. He could not rescind the contract when further faults were found. 3. Lapse of time. The right to rescind will be lost after a lapse of time. If the misrepresentation is negligent or fraudulent, time only starts to run from discovery of the misrepresentation. If it is a wholly innocent misrepresentation, time runs from the entering of the contract. In Leaf v. International Galleries, there was an innocent misrepresentation as to the identity of the artist. The misrepresentation was not discovered until 5 years after the sale of the painting. The right to rescind was lost due to this lapse of time. In relation to economic duress, the time limit is shorter. In North Ocean Shipping v. Hyundai Construction, the Atlantic Baron, a time lapse of 8 months meant the claimant had lost their right to rescind. 4. Impossible to restore the parties to their pre-contractual position. This may be referred to as restitutio in integrum impossible. This is where it is impossible to restore the parties to their pre-contractual position. This may be, for example, where the goods have perished or have been consumed. In this situation, the right to rescind is lost. In summary, rescission is an equitable remedy. It is available when a contract is voidable. This may be because of a misrepresentation, a mistake, undue influence or duress. Rescission involves putting the parties in their pre-contractual position. The right to rescind the contract may be lost if a third party acquires rights, if the claimant affirms the contract, through lapse of time, or if it is impossible to restore the parties to their pre-contractual position. This video is part of a series of videos on contract law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.e-lawrevision.org.uk for revision games and quizzes. Thanks for watching.